Simon Muzait, John Kuria, Peterson Wanjau, Samuel Kangere, Julius Ndunu, Peter Njenga, John Maina, Philip Kabiri, Peter Njoroge, and Joel Muriu.
You are not before. You are waiting for the evening. Yes.
Hearing alongside Simon Guru.
Correct. Correct.
Yes.
Guru.
Mr. Guru.
Yes. Sweet Guru.
Guru.
Yes. Pico. Mr. Pico.
Yes.
And Mr. Onje.
Mr. Mundi.
Yes. Mr. Mundi.
So, Maina. This matter came up before me this morning for future elections. Before this was done, Mr. Njenga, who was the lead counsel for purpose of today's proceedings, made several applications, which I will strive to distinguish. It will only be fair to indicate the appearances. Mr. Njenga appeared alongside Mr. Simon Guru, Mr. Steve Biko, Mr. Munje, Mr. Olali Cheche, and Ms. Mburu. The prosecution was represented by Mr. Maina, the learned prosecutor. Mr. Njenga requested the following documents in addition to the statements already supplied. 1. Covering report. 2. Investigation report. And 3. Crime and incident report. And finally, that summons be issued upon His Excellency Gachagua, the Deputy President of the Republic of Kenya, to appear before this court. This is over the council's strong conviction that the Deputy President was making comments which to him amounted to prosecuting this case in public rallies. He submitted that under Article 27(1) of the Constitution, it is provided for equality before the law, and that His Excellency the Deputy President is subject to the law, and there is need that if he is trained from prosecuting this case before the media. The learned counsel submitted that whereas it is provided for freedom of speech, the same does not include making vilifying statements or innuendos that injures the reputation of others with a strong reference to the accused persons herein. The council made further reference to Article 48 of the Constitution that provides for access to justice. It took issue with the presence of police officers around the court premises and surroundings whenever this case comes up. He stated that this alone harass the accused persons and consequently taking away the right of presumption of innocence upon the accused person. He called that the Deputy President is specifically restrained from making comments on the case herein. He handed over to his colleague, Mr. Biko, who made application for release of motor vehicles. This was by the application dated 14th June 2023. This being a formal application, the prayers were as follows. Prayer 1 was spent. Prayer 2, that the court be pleased to order the respondents and their agents to release the motor vehicles registration numbers HCR 555S, Lexus model LX 570, KAU 831N, Toyota Premium, KAK 628H, Nissan Saloon, KCE 500S, Toyota Land Cruiser, to the applicants upon delivery of identification documents which have already been served upon the state through Mr. Misoi, the investigating officer. 3, that the court be pleased to grant suitable conditions to facilitate compliance and return of vehicles to the applicants in whose custody they were impounded. 4, that the court makes any order it deems expedient in the interest of justice. And finally, that the cost of the application be provided for. The application is supported by the annexed affidavits of John, Maina, Njenga, Joy Muriu, and Stephen Njenga Maina. The counsel argued largely in line with the application before he was partially overcome by emotions. He, in the upshot, asked that the application, which no reply had been made by the respondent, be allowed as read. The counsel, in furtherance to the application, made an oral application for release of the accused person's national identification cards and forms which he said were being held by the investigating officer, and made numerous references to Mr. Misoi. Let me be clear on this. The applicants in the application are Stephen Njenga Maina, John Maina Njenga, Joel Muru, and Base Limited as first 4 applicants, and the respondents are the Director of Criminal Investigation, Nakuru, and Director of Public Prosecution as the first and second respondents, respectively. In response, Mr. Omwenda, the learned prosecutor, had this to say, that the application was not served upon first respondent, hence required more time to respond to that application. On the part of the second respondent, he stated that the document asked for by the learned counsel, Mr. Mungiki, were available and was ready to supply the same. On the issue about summoning the Deputy President, he maintained that no material had been placed before the court, demonstrating that His Excellency the Deputy President was in Sorry. Let me repeat. On the issue about summoning the Deputy President, he maintained that no material had been placed before the court, demonstrating that His Excellency the Deputy President was discussing the case hearing in public. He asked that the gag orders against him cannot therefore issue. On the release of the motor vehicle, the identification card, he maintained that the same had not been particularized. He stated that, as clearly pointed out, the motor vehicles belong to third parties, hence they ought to be notified before the same are released. He maintained that he was not aware whether the motor vehicles formed part of the exhibits. Mr. Onyeki and Mr. Biko maintained their position in reviewing them. This is the court's considered view. I will make determination in the application. I will make determination in this application in the order they were made and outlined in the form of these rulings. I begin with Mr. Onyeki's application calling that His Excellency the Deputy President be summoned before this court to tell the court what it knows respecting this case. As according to the counsel, the Excellency the Deputy President was prosecuting the case in public, a fact refuted by the prosecution. In determining this, it clearly takes me to my directions of 29th of May 2023, when a similar application was made. For clarity, this court has a duty to protect the sanctity of trial and proceedings before it. It is prohibited as a general rule of law. Comments that would amount to subjudice. The facts of the case ought not to be discussed in any forum than the court. In this case, this attracts the punishment by the court where so is established. In this case, I have been called upon to summon the person in the name and form of the President of the Republic of Kenya, who is accused of making comments amounting to subjudice. As I earlier pointed out, in my above direction, that is on 29th of May, this court can only give specific order where satisfied that there is indeed a violation. In this case, and with a lot of respect, no material has been placed before me to demonstrate the asserted contempt by the Deputy President. I maintain my earlier position that materials ought to be placed before me rather than addressed from the bar. I decline to make any orders respecting the above prayer. On the second limb of the application on release of the motor vehicles, I note that there is no formal response to the application. Oral response can only be permitted only to the extent of the legal points of law, and is a general presumption that issues of fact where no formal response has been raised, the facts are not contested. In this application, I do not find any principal response by the respondent to this application, despite having been served with the application on 14th of June 2023. Consequently, I give the following directions respecting that application. 1. That the first respondent within 3 days of today take the necessary documentary evidence respecting the motor vehicles, including but not limited to taking the necessary photographs if need be for purposes of this trial. 2. That the motor vehicles being registration number KCR 555S, KAU 831N, KAK 628H, and KCE 500S be released to the applicants upon presentation of the relevant ownership documents upon the first respondent upon the lapse of 3 days of today. 3. That the motor vehicles referred should not be disposed of or transferred to third parties during the pendency of this case unless with leave of this court. 4. That the motor vehicle shall be made available as and when it shall be required during the trial, and the second respondent, that is the DPP, should notify the defense of such intention should need arise. That the motor vehicle shall be made available as and when it shall be required during the trial, and the second respondent should notify the defense of such need at least 7 days before the date required. That is all on that application. On the issue of the national identity card and the alleged phone said to be in possession of the first respondent, I direct that a formal application be made to enable the respondent to make substantive response thereto. For clarity, should the application be made, the same shall be dealt with without requiring the attendance of the accused persons. In furtherance, I direct that the documents requested, being the covering report, investigation report, and the crime incident report, to be supplied to the defense forthwith. On the final request on the item security, whenever this matter comes up, I, with a lot of respect, do not find any merit on that application. I do not see how the presence of police officers jeopardizes the accused presumption of innocence. I respectfully decline to make any orders on that. Those are the orders of this court.
Your Honor, we will
Yes, Mr.
we will make a formal application
Yes.
to attach the evidence because we have the evidence.
Okay.
Yes.
Yes, and when it is presented. Yes, Mr.
Your Honor, as I indicated earlier,
Yes.
we have an application to make. Pursuant to section 214 of the Criminal Procedure Code. And the application is for leave of the court for the prosecution to amend the charge sheet to include the proper particulars. And we have presented the court a draft of
Yes.
Your Honor, I've separated the court
Include proper particular.
yes, proper particulars which were left out, and to be specific, first with respect to the dates, in count 1, the dates are indicated as diverse dates from 12th May 2023 to 18th May 2023. We wish to the word dates from 12th May. That's the original charge sheet. 12th May 2023 to 18th May 2023. We wish to amend the same to read from the 11th date of May 2023 to the 18th May 2023.
Yes.
That applies also to count number 3 and 4. With respect to counts number 8, 9, and 10, we wish to amend the particulars to include the name of the ninth accused person in the original text sheet. Lastly, Your Honor, yes. Lastly, Your Honor, in the original charge sheet, The name of the ninth accused was written as John Maina Njenga, and we wish to amend the same. I can repeat the original. It's indicated John Maina Njenga, and we wish to amend the same to read John Maina Njenga Kamunya. You know how to count.
You say John?
John Maina Njenga Kamunya.
John Maina
Njenga Kamunya. As indicated in the draft version of the court. So, Your Honor, in the interest of justice and for disposal of this matter in a timely manner, I pray that the application be allowed and that the charges be read afresh to the accused persons in accordance with section 214 of the Criminal Procedure Code.
Yes, Your Honor, we are opposed to that amendment. Your Honor, if you look at the letter, spirit, and the philosophy that underpins section 214, it is very clear that it is the court. It is the court. If the court realizes that a charge is defective, upon the hearing, then the court, for substantive justice, can recommend a judgment, an amendment, or a substitution of the charge. Not because of anything, but because it wants to realize the interest of justice. But here, Your Honor, it is the prosecution that is proposing to amend. The question that calls for answers is, what was the hurry? Why were they in a hurry to rush to court and they had all the time until they even forgot the name of John? They are saying they are giving the name from John Maina Njenga to John Maina Njenga Kamunya. So what was this in so much hurry until they forgot even the basic name? So they are submitting that it would be highly prejudicial and it will cause a miscarriage of justice if it could appear to the ninth accused that actually the state is focusing on him. Because you can see all those change of names is focused on one person. It's focused on the ninth accused. So what is this? That is the common denominator. That they don't want to take chances. Your Honor, the court should ask itself why the prosecution have not answered that question. We submit that allowing that application would be an abuse of the process of the court, and it will cause substantial injustice to the ninth accused, because it will appear as if there is something abnormal about it. We submit also, Your Honor, that it will appear discriminatory, which will violate Article 27, subsection 4, because it outlaws discrimination of any kind, either based on tribe, name, ethnic background, or any ground of discrimination. Your Honor, it will violate his fundamental rights and freedoms as protected under Article 50, Clause 4 of the Constitution. It will also violate his rights under Article 50, Clause 2K and J, because it will inhibit his ability to interrogate and challenge the evidence that is intended to be brought against him. Your Honor, under Article 159, you have powers from the people of Kenya, sovereign powers, to administer justice to each and every person without regard to social status. Let the state tell us why they want to give Maina from number 9 to number 1. He was not even there during the search and the recovery. He was not in the premises. So we want to know, why is this focused? That is an area of interest for us. Your Honor, we submit that doing that or allowing them to do that would be a miscarriage of justice, and that was never intended by the Constitution, which protects the right of everyone once the trial has commenced. If they did not have a case against the 9 accused person or the others, what was the hurry? They could have waited for 1 more week to do a better job. Who is this that was pressurizing them, Your Honor? We really want to know who was pushing this case. Who is the complainant in this case? Because this complainant looks like he's a very influential person, and he can even change names, he can change the numberings, he can change the priority, he can also decide to retain the vehicles. But thank God you have released the vehicles. So, Your Honor, we want the state to tell us what is in a number. Because they are changing Maina from number 9 to number 1 in all those counts. He has mentioned count 8, count 9, and count 10, and he has also talked of count 1. So we want to know what is in number. What is in numbers? What is in a name? Because it is nothing unless you work for a name to make it recognized. There is nothing. So we submit that it will be highly prejudicial to allow this application, and they will come up with an argument that it is their right to amend. Your Honor, we submit that Article 214 of the CPC belongs to the court. It does not belong to the Constitution. I have looked at Section 134 of the CPC. Your Honor, if they change those names as proposed in count 8, 9, and 10, it means the material particulars, the statement of the offense, and the material particulars as contemplated by Section 134 of the CPC, when you read it together with the Article 50, Clause 2A and B of the Constitution, which says the accused should be furnished with the proper particulars to be able to prepare and to appreciate what is against him, so that he is able to interrogate and challenge evidence. So, Your Honor, if that is allowed, it is like changing horses midstream. When we agreed on the competition and have selected horse A, and my brother selected horse B, then we are going to compete on equality of arms. But if my brother is allowed to change horses midstream, and he brings a horse that has taken some concoctions, then the competition will not be fair. So we submit that allowing them to change horses midstream when this case has taken off will be highly prejudicial to the defense case. And we urge you to reject the amendment. Let us take off with the charges that relate to the accused person. If it becomes necessary, Your Honor, you will give directions as at when we close that issue. I rest my case and allow my friends also to give their contribution, their understanding.
With your very kind permission. I will just discuss some ways. I'll just highlight 2 issues. That is in respect to Section 214 of the CPC and the requirements thereof, in terms of the application that has been done by the prosecution. This is in respect to whether the charges are defective, either in substance or in form. In the application that is before you, Your Honor, I humbly submit that the DPP has neither pointed this honorable court to the defect, either in the substance or in the form of the charges that were previously read to the accused persons. Bearing that in mind, Your Honor, I will humbly ask the court not to be swayed to exercise its discretion as granted under Section 214, noting the fact that the previous charge provides sufficient information to the accused persons of the specific offenses. It provides sufficient information of the specific offenses that are faced the accused persons, and that has not, and that that has not changed, or the prosecution has not shown that that information has been altered by the information that they seek to bring in now. Lastly, Your Honor, is reiterate the point that my senior has alluded to of a specific prosecutorial tendency that is geared towards one accused person, despite there being 12 other accused persons before you. What is the interest of the state in respect to this one accused person, who now in the intended amendment will be accused number 1, and in the previous amendment was accused number 9? What is that interest? I rest my submission. Thank you very much.
I don't know if I may give a brief response. It's right here that the prosecution can amend a charge sheet at 10 times before close of the prosecution process. And that has to be done with the leave of the court. And that is why we have moved the court pursuant to Section 214 of the CPC. Secondly, Your Honor, the defense has indicated that the accused persons will serve prejudice. I submit that no prejudice would be vested on the accused person, considering that the trial of this matter has not started. Today's mention was for the trial elections. Your Honor, I wish also to respond to the issue raised by my learned senior, the big on changing horses. No horse has been changed, Your Honor. It's just giving the proper name to the proper horses and giving the proper dates when the offenses were committed. So no prejudice within this trial. Your Honor, the purpose of Section 214 is to help cure substantive defects and the form of defects, Your Honor. As I indicated in my application, the name of the named accused person in the original charge sheet was not indicated appropriately, and we want to use this proper name, Your Honor. I also made application grounded on the basis of debts. We submit that the debts indicated in the original charge being 12 was not the debt of the commission of the offense, and we want it to be changed to 11, so that when the court is hearing the matter, it can hear it, and the prosecution can present evidence supporting the offense which we are bringing for you. So, in view of the conditions which are met, I humbly urge this court to allow the application for amendment of charge and for the charges to be read with the accused persons. Thank you.
You can give us a ruling date so that we go through. I can see council is putting pressure on you. You have no pressure. You want to decide.
Mr. J. We must move forward in this matter. When it is taking 20 breaks, I go.
Yeah.
Tell to give me 20 minutes.
Can we come back before you tomorrow so that we have enough time?
Today, we must make a step in this matter.
Yeah.
Yes, can we resume in 20 minutes? That will be about
We can resume
5 minutes.
We can resume at 2. Give you fair chance.
No, that's just split at 1. Exactly 1.
Okay.
Right? Thank you very much.
Sasa